welcome to this webinar where I am going to go over the 5 essays and the PT from the California bar exam from July 2024. My name is Maureen. I am the founder, CEO, president, creator of BarMD. We're a full service bar prep company. We do California, that's what we started with, and we also do UBE and also work with some other states too. We have everything you would need for the bar. So we have, stuff for the essays, we have stuff for the PT, stuff for the MBE. We have books, workshops, full courses that cover everything, you name it. Lots of different things that I, think are really needed in the market. I think our stuff is very different from what else you will find out there because the focus at BarMD is to show you how to do something. That's the big difference, is we want to show you how. So through our processes, we walk you through step by step how to write a passing essay, how to write a PT, how to write different types of PTs. I've also just been working on revamping all of our workshop courses for the essays and for the PTs to focus more on strategy as well, to focus really on the how, adding some additional exercises into the PT courses, etc. So I'm super, super excited about that stuff. And a couple other things. So also, if y'all have any questions please put them in the Q&A section. The Q&A section will be the best spot because it'll get lost in the chat and I won't see it. So goals for today: understand the issues in the July 2024 bar essays. I'm also going to talk about scoring, also talk about the July 2024 PT. So just a couple of announcements. One, for those of you that don't know, you can do a free score review with me. A couple of them are with a member of my team, just to cover some times that I can't come. But you can do a score review with me. It's totally free. And if you haven't done that yet, you should. We will go over your scores. I'll help you make sense of it. We will look at your essays and your PT, and we'll help you strategize to come up with a plan to pass. So I'm going to put that link in the chat right now. So if you want, go ahead and schedule a free score review. Also, next Wednesday evening at 6 p.m. Pacific time, I'm going to do a webinar where I am going to walk through in a detailed way all of those 25 multiple choice questions that were released for California from Kaplan. So I don't think the answer explanations are all that great. I am an expert at the multiple choice on the bar exam. I know every single question that has been released. I know the tricks that they use. I know the way they are written. I know a lot. I know the trips, like the traps people often fall into, etc. So I am doing a super detailed webinar next Wednesday. You should absolutely not miss it. Join live. There is the link. I just put it in the chat, and I'm actually going to turn off the chat for other people to be able to write. So that way it's just the things that I put in there for now. If you have a question, put it in the Q&A. But make sure you do that free score review and come to this webinar unless you're taking the attorney exam. One other thing that's not on there is if you are a former BarMD student and you need to re-access the materials that you bought in the past, here is the document. It's just a survey. It's quick. We just need you to fill that out. Once you fill it out, give my team like 48 hours and we'll get you re-enrolled. So 3 important links that I just put in the chat. So take advantage of those, get stuff scheduled, etc. And those meetings should be with me for the most part. So just also a quick plug here. Well, I've got a captive audience before we get into all the, everything. We have our Core Plus program starting soon. So this is our bar prep program. It covers the essays and the PTs. I also have a version of it with the MBE. I just know that most people already have Adaptive or UWorld or something like that. So Core is $9.99 for daily study schedule, outlines, essays, model answers, lectures. And we're not black letter law lectures like you've done in Barbary or Themis or Kaplan or whatever it is that you have done. It's different. These are lectures that talk about strategy. They talk about how to approach the questions. They talk about frequently tested issues in every subject. I talk about organizational issues that you will likely see come up within a given subject and how to deal with the common issues in that subject. So I really try to show you how to write passing answers. Plus, there's essays that you write, and most of them have a video breakdown of me walking you through that essay, me or one of my team, walking you through that essay, talking about the strategy too. So I know that, I don't find it helpful to give you just an absolutely perfect model answer. I want you to know, how do you write a 60? And then how do you go to a 65? How do you go to a 70? Not just giving you 100 and telling you to figure it out, right? So like you have to scaffold it up. So that's really what we do. That is the heart of the program. Plus we have Core Plus, which is something that's new. And if you did Core before, you can upgrade to Core Plus. But this is like for people that want more individualized attention, you want more live classes, and the books that I've written. So I've written the Best Bar Essays template book. I wrote a PT book also, that again, these are a labor of love. They are different than what is out there. And I promise you that. On our website, there are places where you can download a free sample, so you can look at a portion of the book or of the books to get an idea. I also have an MBE book that I've written. It's not included with Core Plus. And you also get 3 tutoring sessions. So 3 45-minute tutoring sessions plus an intake to strategize, so that we can look at your work, make sure you're on pace, like help you fix your writing, help you look at your MBEs, all of that. And then we have these essay checkup sessions. These we introduced on the last bar, and they are like one of the things that people have loved the most. And they are, it's a session where you join for 3 hours, and we give you the materials. You're either going to write 3 essays or 2 PTs. We give you the materials, you go for it. It's proctored, all of that. And then you take a break for an hour, come back, and then we're going to actually walk through either the 3 essays or the 2 PTs live. So everybody has loved those. It really puts you in that exam environment. So those have been really, really, really popular. So all of this stuff you can buy individually too, but we have it as these bundles. And then also, just as a heads up, we have our workshop courses. So if you don't need the full bar prep, if you're like, I really just need help on the essays, I really just need help on the PT or the MBE, these courses start basically December 1st. So mastering essays, mastering the PT, MBE minutia, and then our books are available too. So lots and lots of options out there. To me, it's really important too that there's stuff at every price point. If you don't want to go a full bar course, or maybe, it's just not in your budget, that there is stuff that's accessible, etc. And I do quite a bit of free stuff. I have a podcast that I'm starting to actually record again. I have a YouTube channel, all sorts of stuff. So lots and lots of materials out there, so you can sample the classes that we do, etc. All right, and then just a note on tutoring. For those of you that are interested in tutoring, I am getting very full. So I'm getting there. I have my staff tutors that are excellent, but I just want to mention, for those of you that are considering it, I know there's a bunch of people here that I've talked to. So if you're interested in that, it's something you want to think about. You don't have to do it like right now, but I just wanted to mention that. All right, now let's get into the stuff you're really here for. July 2024 scores. So the score required to pass each written event changes from bar to bar. You always need a 1390 on the written portion and on the MBE. But what it takes to hit a 1390 is different each time, slightly. And that's when they do the scaling, what they're doing is they're saying, okay, was this MBE administration more difficult, or this multiple choice administration difficult? If so, then they're going to make it the score to pass each written event a little easier, and vice versa. So the score required to pass each written event was a 61.2. It's been above a 60 since 2020. So it's, you always want to be shooting for those 65s across the board. And we teach you how to do a 65. Like, that is something that's really important to me, is to show you exactly what you need to do to hit that 65. And then on this bar, so if you look at your score sheet, and you'll see all of the scores that you got for the essay portion, or the essay and PT, the written portion, and you'll see a raw written score, and you needed to get a 430. I think you might have been able to get a 427.5, but you would only get that if you had a second read. So it's really that you need to get a 430 to pass, to get about a 1390 on the written portion. On the MBE, so we look at percentile rankings. That's the only information that they really give us, is we know you need a 1390. And historically, I've been looking at this data over and over. and you need to be in about the 48th percentile from a July exam to get that 1390. So you can look at your various subjects and see how did you do. But overall, your score nationally should be in the 48th percentile. So just as a heads up on that, just to give you an idea of where you need it to be. So if there are any questions on that, I'm going to check the chat or the Q&A real quick if there's any. You need an overall 1390. So the 1390 is what you need overall. In each, and the MBE counts as half and the written portion counts as half. So you need to average a 1390 in the written and in the MBE to get an overall 1390 score. Because it's whatever your score is, your scaled score for the written. Like if it's a 1390, they multiply it, they times it, they cut it in half, and then they add that to your MBE scaled score cut in half. So it's a 1390 across the board. All right. For the anonymous person that asked about the attorney exam, attending the 25 questions, I don't think you need to come. I wouldn't do that. All right. Now, let's get into, each written in MBE, each need to average a 1390. So you can get a 1400 in, in one portion and a 1380 in the other. That evens out to a 1390. So you just need to average a 1390. So let's get into these essays. Let me first pull them up on the screen. And yes, this session is being recorded. You just want to hang out till the end because I'm going to do a little special. But yes, it will be recorded, and we'll send out the link to watch the recording tomorrow. We'll send it out a couple of times, but first tomorrow. All right, so I've got the fact patterns pulled up here. So first here we have, I always start with the call of the question. So upon what theory or theories may the PIC shareholders bring claims against Alex and Baker, and what is the likely result? Discuss. And upon what theory or theories may the PIC shareholders bring claims against Kate, and what is the likely result? Discuss. For everybody following along, just as a heads up, for everybody following along, you might want to just, I hope you're taking notes on everything I'm saying and the notes from the PowerPoint. You won't have the PowerPoint afterwards, so definitely take notes. And then that way you can compare your answers to see, did you address the same issues? Things that you won't, if you're like, well, I addressed those issues, but I still didn't get a high score. If that's the case, it can really be in your analysis. So, and that's something that I will look at, or we look at when we do your score review. So I'm just talking about the issues that you needed to address tonight. That's what we're really focused on. So PIC Winners PIC is a corporation that markets to wealthy investors who want to trade stocks online. So one thing I want to point out as I read this, and this is stuff, I'm just going to give you guys some bonus tips to help you as you're prepping throughout this. I'm going to give you some bonus tips. One thing that's really important is to pay attention to adjectives and adverbs. So right here, it says they market to wealthy investors. So they're limited. They don't just market to everybody. So I'm like, all right, they told us that for a reason, and it is important in this fact pattern. Every single fact in a California fact pattern is significant, and you need to use every single fact. That's another reason we see scores that are at a 60 or at a 50. A 55 usually means you're missing issues. Usually means you're missing at least one big issue, also some smaller ones. A 60 means you addressed the issues that they were looking for, but it's lacking in depth. Don't use all the facts. You're not including relevant counter arguments, stuff like that. So just to kind of give you an idea as you're really interpreting your scores and looking over your essays yourselves. So PIC Winners Inc. PIC is a corporation that markets to wealthy investors who want to trade stocks online. The shareholders of PIC elected Alex, Baker, and Kate as the sole members of the board of directors. Okay, so there's shareholders, and then we have the board. Kate believed that Alex and Baker caused a decline in PIC's market share and stock price by focusing exclusively on wealthy investors, thereby ignoring average consumers and losing the low-priced end of the trading market to other companies. So this is where it's like, all right, they're focused on wealthy investors, right? She thinks that's problematic. She thinks that at A and B caused a decline in the market share. So immediately I'm thinking, all right, is there a breach of the violation? Is there a violation of the duty of care? I'm thinking of that by focusing exclusively on wealthy investors and ignoring the others. At a board meeting, Kate told Alex and Baker that she planned to start a competing company called Easements, Inc. So that would automatically trigger a duty of loyalty issue, unless A and B agree that PIC will form a subsidiary to focus on the low-priced end of the trading market. So she does present this opportunity to the board, and the question is, do they listen? Kate stated, Pitt can capture the low-priced end of the market with a subsidiary that advertises on social media platforms. Otherwise, Pitt risks continually losing market share and value. A and B disagreed with the proposal and responded, Pitt's decline just mirrors the overall recent decline of the stock market. So they're having a good discussion about this. They're like, look, like this is getting into a whole business judgment rule analysis. And there was a lot of depth here about should they have, formed this subsidiary or not? Did Kate adequately inform them of her plan? Did she adequately present it to them, etc.? There's some ambiguity with all of that within her duty of loyalty. They also reminded Kate that we hired an analyst 2 months ago who looked at the low price end of the market and concluded that there was no money in it. So that's a big, big hint that there's probably not a breach of the duty of care, right? Hindsight's always 20/20. We know that Kate's going to be successful. So hindsight's 20/20, and they're like, oh, you can't use that against them. Business judgment rules, did it make sense at the time? They didn't think, they give reasons. They say that look, it's the recent decline of the stock market, and there was an analyst that advised against this, and you can generally rely on trusted analysts. So I would have addressed that. Kate replied, if Pick won't do it, I'll form such a company myself. So really, can she do that? And, I would argue that it's not in the same, for duty of loyalty, there's the various different tests of, is it in the line of business? Is it, usurping an opportunity, right? You can use those different tests, and you could maybe say that there was a violation, but then also there's the exceptions if you presented it, etc. So Kate subsequently formed eSave on her own, and eSave soon began generating large profits. Meanwhile, Pick's market share and stock price continued to decline. Several of Pick's shareholders learned of the board's actions and Kate's operation of eSave. Their written demand, so the fact that they file a demand means we got to talk about, is this a derivative suit? Is it a direct suit? It's going to be a derivative. They have to file a demand, which they do. So you're going to talk about that. Really small issue, but get it in there. That the board take remedial action. The written demand that the board take remedial action was denied, and the shareholders now plan to file suit on behalf of Pick. All right, so then going back to our questions. So a lot baked in here. Now I have a question. I'll turn the chat back on. As I'm going through and reading this, and I'm talking about the little detail and the ambiguity, did you guys see that? Do you see it now? I'm just curious, because that's the level of depth you need to be going at these. And it's okay if you didn't. Good, I'm glad some of you did. Good, good, good. Yeah, did you see it then? Good, I'm so glad. So getting at that level of detail is really, really key, and explaining every little fact. So let's get into the presentation. So these are just the issues that I would have addressed. These are my headings. So upon what theory or theories may the Pick shareholders bring a claim against Alex and Baker? What's the likely result? So derivative suit, and then issuing the demand, talk about those issues. Breach of the duty of care. I would have talked about, was it a breach of the duty of care? That's ambiguous a little bit, because you could talk about how the company is only done to, formed to market to wealthy investors. So if that's what their purpose is, and they don't necessarily have to go beyond that, that would be an ultra vires acts, potentially. You don't need to get into ultra vires acts, but there's a lot there. Then is there a breach of the duty of care? Going into reliance protection. So talk about that, relying on that analyst, and also the business judgment rule. So really deep discussion of the breach of the duty of care itself. So there'd have been a big rule and analysis under this heading, big rule and analysis under each of these headings: reliance protection, business judgment rule. So a lot happening here. Then upon what theory or theories may the Pick shareholders bring claims against Kate, and what is the likely result? This, again, derivative suit, demand, and then also a very big, hearty discussion on the breach of the duty of loyalty. I didn't put it in the headings here, but I would have talked about those various tests. So usurping a corporate opportunity, line of interest, line of business. I think those are the 3 tests. So I would have definitely talked about each of those. So this is just a big, sort of standard, but very, I think there's some ambiguity. I think it's fairly ambiguity laden. And that's something often when I see an essay that gets, a 60, they didn't include counter arguments, didn't address the ambiguities, didn't use every single fact. And I mean every little fact. I can give you the rule for demand later. You just have to make a demand unless it's futile. All right. And this property essay is a doozy. Let's get into this one. This is the one that I heard the most people sort of freaking out about, validly so. And actually, do you guys want to see what I want to show you what I mean when I say using every little fact And I want to see, did you guys see all of this? So I'm going to do it. This is something I show people all the time, and they're sort of blown away, is identifying every little fact. So here, Pick Winners is a corporation. That's one fact. That markets to wealthy investors. That's a new fact. Who want to trade stocks online. That's a new fact. The shareholders of Pick elected A, B, and C as the sole members of the board of directors. That's a fact. Kate believed that A and B caused a decline in Pick's market share and stock price by focusing exclusively on wealthy investors. That's a new fact. I'm not going to get into the substantive law of all this stuff. Like, that's not, we don't have time for that. Thereby ignoring average consumers and, right, that's a new fact, and losing the low priced end of the trading market to other companies. So every time it switches colors, it's a new fact. So you'll start to see, right, as I break this up, did you see every single fact that's unique? And every single fact in here should be explained in its own sentence and tied to the law for a really good answer, Then there's at a board meeting. I'm like, oh, you needed to use that. That's a fact on its own. Kate told A and B that she planned to start a competing company called eSave unless they would agree that Pick would form a subsidiary to focus on the low end of the trading market. That's really all one fact. Kate stated, Pick can capture the low price end of the market with a subsidiary that advertises on social media platforms. That's another new fact. Otherwise, Pick risks continually losing market share and value. So she's like warning them. Alex and Baker disagreed with the proposal and responded, Pick's decline just mirrors the overall recent decline of the stock market. That's a fact. They also reminded Kate that we hired an analyst 2 months ago who looked at the low price end of the market and concluded there was no money in it. Kate replied, if Pick won't do it, I will form such a company myself. Kate subsequently formed eSave on her own. So she does it. eSave soon began generating large profits, right? So that's going to go against, people want to say it was a violation, business judgment rule, you can't use hindsight. And then Pick's market share and stock price continued to decline. Then several of Pick's shareholders learned of the board's actions and Kate's operation of eSave. Not really something you need to use, but their written demand that the board take remedial action was denied. That you want to use. And the shareholders now plan to file a suit on behalf of Pick. That you don't really. This is sort of background information, but so the thing is, it's surprising to see how many different facts are in a single fact pattern that you need to use and explain, and how, you can, a single sentence has multiple facts. I know we generally know that, theoretically know that, but I like to show really how many facts are in a fact pattern. When I talk about using every fact, this is what I mean. People will often think that they used every fact because they used a whole sentence. And then also, did you explain the significance of the fact, right? So it's a corporation. It has shareholders. They owe a duty of care, duty of loyalty. They market to wealthy investors, right? Okay, so if their purpose is to market to wealthy investors, maybe it's not a violation of the duty of care because they're just supposed to focus on what they are formed to do, right? And it's focused on people that want to trade stocks online. Fine, that's what they're going to do. You might use this in the same sentence, but see that there is a difference there. So anyways, I'm not going to do that for all the essays, but I like to just show that. And this is a lot of what we teach in the classes. This is a lot, this is some of the strategy. You need to know this stuff, and people can tell you to use all the facts, but you need to see, okay, well, how many facts are there? How do I break up the facts? All of that stuff. Let's get to the next essay, property. So what property interest, if any, does Darla have in Lot B? Discuss. And what claims may Simon make to maintain a right of way over Lot B to the public highway? Discuss. All right. So Olivia owned Greenacre in fee simple. Greenacre consisted of two unimproved adjoining lots, Lot A and Lot B. A dirt road led from Lot A across Lot B to a public highway. 60 years ago, that's a long time, Olivia conveyed Lot B to Barry as a gift, subject to the following clause. If at any time Barry, his heirs, successors, or assigns shall use the premises for any purpose other than as a personal residence, said Lot B shall immediately vest in fee simple in Zach or his surviving descendants. So we have to deal with this clause. It's a restraint on alienation. There may be a wrap issue here. Shortly after receiving title, Barry began living in a cottage he built on Lot B. Like, is there some adverse possession happening here? Maybe, maybe not. At the time of the conveyance of Lot B, Zach had not yet had any children. Zach has since died, and his granddaughter Darla is now his only surviving descendant. And actually, it's not adverse possession. Barry is who got it, and he's using it as a personal residence. So it's in what he's doing, living there, comports with the restriction here. Okay. At the time of the conveyance of Lot B, Zach had not yet had any children. Zach has since died, and his granddaughter Darla is now his only surviving descendant. 30 years ago, Olivia died. Her son Simon inherited Lot A. He built a house on Lot A 1 year later. Through the years, Simon regularly used the dirt road across Barry's adjacent Lot B to get to and from his house and the public highway because there was no other access. That looks like an easement by necessity. 4 months ago, Barry sold Lot B to a developer for $1 million. Developer demolished the cottage, so violating the clause, but if that clause is enforceable. Began constructing an office building on the lot and began closing up access to the dirt road from Simon's house. All conveyances properly recorded immediately after execution and delivery. One thing, and I'm not going to get into it here, you have to know how to organize property essays. There is so much happening and you got to go through it chronologically. Like, you can't just say what property interest does Darla have in Lot B. You have to go through every single thing that occurred to answer that. So let's go look at my outline. So what property interest, if any, does Darla have in Lot B? So first, O's conveyance to B. So O owned Greenacre in fee simple absolute. Then B's interest. They had a fee simple subject to executory interest. I like to just go chronologically and say what each person had and define that and kind of put the issue in the heading. Then there's an executory interest to Zach. And the executory interest is subject to RAP and it violates RAP because Z is a life and being. It's not certain to vest in Z within 21 years. So that violates RAP. So that interest is invalid. Then Z died. D inherits from Z, but Z had no interest. So Z has, in Greenacre. Sorry. Yeah. So D has no interest. That should say D in Greenacre. And then the sale, the restriction was invalid. So building the commercial building is totally fine. I've seen other people that have talked about this as just an unlawful restraint on alienation. You could look at it like that. I think I'm curious to see some essays where they did that and to see the scores. I haven't seen that a whole lot yet, but I am curious to see that. And then the claim to maintain the right of way over Lot B. I would also say easement by necessity. So I would go through that. They say there was no other access. You might have also raised that it was an easement by prescription because he regularly used a dirt road through the years over a period of 30 years. So that's essay 2, bit of a doozy. I think property essays tend to be like this, where it's just so much going on and you really have to know how to organize. And somebody asked in the Q&A, like when approaching essays in bar prep, you don't always do one or the other where you either let the facts drive the structure or always issue spot first and plug in facts. It's actually different than that completely. Some fact patterns, you really let the fact pattern drive your structure. Other ones, it's really focused more on issue. So honestly, it depends. And that's something we talk about. Like I've been recording these lectures saying, I did a whole thing on organizing property essays. All right, let's do a little PR. And somebody asked, how does one answer in 1 hour with the issues in the law? You have to practice close note times and you have to know strategy. That's why you have to know how to write a 65, not just how to write 100. You cannot write 100 in 1 hour. So that's not your goal. All right, PR. Somebody asked, do you use your own words for the facts? You just copy it. Just write the facts as they're written. Don't try to change it. Don't paraphrase. All right. PR is one that's tricky to organize. And there are different ways you can do this. This is why you really need to know strategy and why to do things certain ways and what are the different ways you can approach something. And also when you're writing a practice essay and then you compare it to Barbary or Themis or whatever, or even mine, if you're in my full bar prep, just because I did it one way doesn't mean it's the way that it has to be done. It can be done different ways as long as it makes sense. That's something that I often talk with people about just generally, especially when I'm tutoring. But I just want to mention that. So, when y'all are self-assessing, right? I don't want you to freak out just because yours is organized differently. Were the issues clear? Did you come to the right conclusion? Did you use all the facts? That's really what matters. That's really what matters. The other thing I want to say is for a lot of people, I find that when they took the bar exam and then they're repeating it, they're like, I was doing so well on my essays, I was passing all of them, etc. If you are self-grading and giving yourself passing scores, I'm going to ask you to be a lot more critical. In our brains, we tend to fill the gaps. You're like, what you meant, and you have to really say, did I actually say that? That is a massive issue that I see when I am going over people's bar essays. It's conclusory writing. It's just stating facts. It's actually doing the analysis. It's actually using because in every sentence of analysis, stuff like that. So yeah, that's like another little tip, is just to be like, don't really cut yourself any slack to a point, right? Like I'm really, really hard on myself. So, but I didn't cut any slack. Okay, so let's go through this one. This is our PR essay. One thing about PR essays, it's going to be on the exam. Everybody knows it's going to be on the exam. It's required by California law to be on the exam. That means that everybody studies for it pretty hard and everybody does pretty well on it. So it can actually be a little tougher to do well on it because of that, because everybody tends to push for it really hard. So if you're like, I crushed it, I did so much practice, but you're still disappointed with your score, it's because everybody sort of does. And there's not a forced curve, but they will look at, when they do the grading calibration, the bar graders get together, they know what a perfect answer would have, they write answers, they research, they do all sorts of stuff. And then they sit there and they start comparing and saying, okay, well, a 65 would have addressed this, and this. And it just might be that like a PR essay, they're just sharper. Where like on that property essay, maybe a lot of people missed a lot of stuff. And so they're like, all right, a 65 needed this. So it might just be, it's not a curve per se. It's just that there is some understanding of like, difficulty level. And then also how there is some about how everybody did, but there's not a forced curve where it's like only a certain number of people can get an A, B, or, 60, 65, et cetera. Like that doesn't exist. All right. August is an attorney who represents Paul in a lawsuit against Paul's former real estate broker, Danny. All right. So we've got an attorney here, and there's this broker, Danny. A and P have a valid written contingency fee agreement. They tell you it's valid and they tell you it's written. Don't spend a lot of time. You're going to talk about the fact that there is a contingency fee agreement, but you're not going to go into detail and go crazy on all those rules. That's a huge mistake. I've seen so many people do it. You always need to address the stuff that's actually at issue. So I'm going to talk about the fact of the fee agreement, but I'd be like, yep, it was valid, written, fine, done. I'm not going to be like, well, they needed to do this and this and this and this and this. And if they didn't include this term and that term, they told us it was valid. I'm not even going to include all the detail in my rule because I don't want to spend my time and energy there. This is part of the strategy. This is part of how do you write a passing answer in an hour. It's knowing stuff like that. Paul alleged in his lawsuit that Danny was negligent in a real estate transaction, resulting in a lost opportunity to buy land, which could have been sold for $1 million profit. With Paul's permission, August sent a written settlement demand for $500,000 to resolve all issues to Danny's lawyer, Len. They like naming lawyers, Len. Len did not respond to the demand and did not communicate the demand to Danny, right? That's obviously a problem, duty to communicate. One evening, Paul saw Danny and asked her about the settlement demand. And yeah, so Paul sees her. Danny told Paul that she had no knowledge of the settlement demand. Paul told August about his conversation with Danny, and August did nothing with the information. So does August have to do anything with the information? I want to call August Augie, so we're going to call him Augie. At Augie's request, Paul contacted Danny, communicated the settlement demand, and explained why $500,000 was a good offer. Paul's talking with a represented person, can't do that. Because it's, Paul is doing it at August's request. So that's why it's a violation of duty to communicate, or it's really a duty of fairness issue, truly. Communicating with represented parties. Danny asked Len about the settlement demand. Len told Danny he did not respond because it was too high for the value of the case. With Paul's permission, August told Rita, an attorney in another law firm, about the lawsuit against Danny. Rita said she knew Danny and could work with her. August asked Rita to assume joint responsibility for Paul's lawsuit in return for 50% of August's contingent fee. Rita agreed, and Augie wrote to Paul explaining the new arrangement. Within a matter of days before Paul received August's letter, Rita settled Paul's lawsuit against Danny for $500,000. So what ethical violations did August commit, exist in A&R's agreement, and then did Len commit? So I always like to start off by establishing the attorney-client relationship. Not necessary, but I just always do it. Then contingency fee agreement, very brief, valid written contingency fee agreement, no violation. Then the demand letter. And so here I'm organizing it by each sort of issue, which is the contingency fee agreement, the demand letter, doing nothing with the information from P. So the demand letter. So A sent the written demand. P gave A permission to send the letter. There's no violation here. So that's totally fine. And doing nothing with the information. Yeah, this is just on the next slide. A knew L had not told D about the demand, and A is not required to send a demand or to do anything. His duties to his client, he's not supposed to talk to the other side. So again, a lot of stuff here is like no violation. And I think that tends to throw people off. Is you want to come up with a violation because it seems like it should be really easy. And then also P contacting D, communicating with a represented person. A knew D was represented by an attorney, did not get L's permission to speak. So that's the violation there. Settled the case for 500K. D had P's permission to demand 500K. R settled the case. Does it appear settlement was communicated to P? So you can organize this. I like to do it sort of factually. On different PR essays, I organize them differently. I sort of let the facts drive me, and that's okay. You might have done duties in your headings. I often, will include the duties in my heading, but you can do that too. It's fine. If you did it just by duty, it's okay. What matters the most is there is often so much ambiguity in PR. There's a lot of ambiguity, and you have to use every fact in the fact pattern. So there's a lot. I'm just mentioning, the sort of nuts and bolts of this. Oh, oh my gosh, I don't have the PowerPoint slides up. Sorry. Thank you, Aida. All right, let me just go back. So ethical violations, did A commit? So I said attorney-client relationship, contingency fee, get in and out, no violation. A sent a written settlement demand. P gave A permission to send the letter, no violation. Go to the next slide. A doing nothing with P's info. That's fine, no violation. Not required to send a demand or do anything. P contacting D, there's a violation. And then the settling of the case for 500K, D had P's permission to demand 500K. And so given that they did the demand, probably should have communicated. So I think there's a little bit of ambiguity here. They demanded 500K, but still every offer to settle, you should communicate. So there's probably going to be a violation of the duty to communicate, but I think there could be some ambiguity here given that he had the permission to demand 500, presumably he would accept that. All right, in A and R's arrangement. So here, 3 things: duty of confidentiality, fee splitting, and fee splitting. So with confidentiality, right, with P's permission, A told R, an attorney in another law firm, about the lawsuit against D. R said she knew D and could work with her, so there's no violation there. But the fee splitting is a problem. So, and 2 parts of it: communicating the fee splitting to P, it wasn't communicated. So there's a violation for not communicating the fee splitting in advance. And then also in the amount, when we split fees, it has to be under the ABA, it has to be proportional to the amount of work done. It's unclear here. It happened within just a few days, but A just did a demand letter. And California just can't be unconscionable. So it's probably going to be okay in California. There's some ambiguity under the ABA. So this is unclear. We need more facts. And what about Len? He violated duty to communicate. Pretty obvious, right? Didn't respond to the settlement demand, didn't communicate the offer to D. He said too high for the value of the case, but you still got to communicate it, right? So violation. All right, y'all hanging in there okay? Am I keeping y'all? You need to take a little stretch for a second. And I know there's some people with raised hands. I'm not going to answer those right now. I'll answer them at the end. Good. Okay, good. I'm just going to have a sip of my tea. Fairness goes to communicating with the representative party. That's on the second issue. Somebody asked if there's any unfairness to opposing counsel. All right, let's go to and duty to financial responsibility compared to contingency fee. That's fine. Let's go back and look at the fact pattern again. All right, so this lovely Civ Pro essay. Oh, just going back to PR. There should have also probably been a duty to report, right? Duty to report. So I don't really think there was diligence and competence here. Those are things that people like to throw in, but the way they test those weren't present here. You could throw it in, but I don't think it's gonna really do anything. I don't think it's really necessary. All right, let's go to question 4. This question, did this throw you guys off? The Civ Pro, Cal Civ Pro. I think it threw off most people. One thing that I am paying attention to, and when I do my final forecast session 2 weeks before the bar, one of the things that I look at is what is the UBE tested recently that are sort of weird issues, because they like to test the same sort of weird issues in close time to each other. So like the UBE did RAP in the early 2020s, 2020, 2021, 2022, like around there, maybe 2019. They did RAP like 3 times. Then we see it here. There's been a ton of this, like, all right, they just tested this and we're going to do it in California. So I look at all those patterns and help prep for that too. But this is, getting a motion and getting, this preemption, or, a peremptory challenge was interesting. Yeah. So CalCiv Pro, this is the 3rd time CalCiv Pro has been tested, right? It only became testable like in 2010. So, it hasn't been tested all that much. because it hasn't been around as a subject as long as others have. Sarah, I don't understand the question. All right, let's look at this one. So did the court err in seating juror number 5? Discuss. Did the court correctly deny Palma's motion for directed verdict? Discuss. And how should the court rule on Palma's motion for a new trial? So they love to do these like motions questions in the UBE. So I was like, oh, they finally did it in California. So this was not a surprise to me. They haven't done a motions question in a really long time. All right, a car manufactured by motor with an accident. And especially like if you didn't read the call of the question first, you're probably thinking that this is torts when you read this. A car manufactured by motor with an accident. Palma was in the front passenger seat during the accident when her seat collapsed, resulting in serious injuries. Palma properly filed and served a complaint in California Superior Court against the manufacturer, Motor, asserting defective seat design. During jury selection, juror number 5 revealed that she had worked as a motor engineer before retiring 5 years ago. So there's obviously a conflict here. Juror number 5 also discloses she still owned 50 shares of Motor stock, which amounts to 2% of her total financial assets. Palma challenged the seating of juror number 5 for cause. The court denied Palma's challenge because juror number 5 said she could be fair and impartial. During trial, Motor presented evidence that the seat was not defective and that any injuries Palma suffered were due to reclining the seat to an unsafe angle. Palma submitted evidence that at the time of the accident, a bookshelf was in the back seat, which prevented excessive reclining. At the close of evidence, Palma moved for a directed verdict, arguing that misusing a product is not a defense to defective design when that misuse is foreseeable. The court denied Palma's motion and a jury verdict was issued in favor of Motor. 2 weeks after the jury verdict and judgment, Palma received anonymous reports of motor safety tests conducted 3 years earlier. The reports showed that severe injuries were likely regardless of the angle of the seats. 1 week after receiving the reports, Palma filed a motion for new trial, arguing that the verdict was flawed, provided evidence that Motor had intentionally hidden the reports. All right, so I don't think this one is too crazy if you know these issues and you know what the rules are, and that's the challenge. You also have to know what to do when you don't know what the rules are, and I do teach that in the final forecast. And yes, y'all will get a link to watch this recording, so if there's questions about something I said in a prior one, you'll be able to go back and look at it. But definitely stay on till the end because I'm going to give a little discount code. And I've never, ever done that before in these. So did the court err in seating juror number 5? There's a lot of ambiguity here. So there's bias, conflict of interest, former employee for defendant. So they retired, but they retired 5 years ago. So like how much like do they really care, right? They don't still work there. So, and it's 5 years ago, there's been enough time. So they could still potentially be, impartial. But then also the stock ownership. They still own 50 shares of Motion stock, but that only amounts to 2% of their total financial assets. So this person sounds maybe like they've got some money. So maybe this isn't that big of a deal and maybe they can be impartial. So there's ambiguity here, but, and this is my conclusion, but I think you could go the either way. Even if the juror could be fair and impartial, I think the conflicts, the fact that there's 2 of them warranted striking the juror for cause due to a high potential for bias. And like, yeah, and I will just leave it at that. There's like other theories I could go into, but I think that's just, you need to leave it at that. But this bar exam, I think in particular, there is so much ambiguity all over the place. And if you were missing that, it can explain why you're not getting 65s. All right. And what about the motion for a directed verdict? There's got to be no reasonable basis to find for the non-moving party. A reasonable jury could find for Motor. Courts should have granted the motion for the issue raised. Foreseeable misuse is not a defense in products liability. Court did not need to grant the motion for the directed verdict overall. And then also timely, right? So we're going to check out the substance of it and then also the timing of it. Then the motions for a new trial. So you have to have a proper grounds. So they proved Motor intentionally hid reports that showed severe injuries were likely regardless of the angle and hurt angle of the seats. So motion for a new trial, if there's fraud, that's definitely a grounds for a new trial. And then again, the timing of it. So it's timely as long as notice was filed within 15 days after service, because filed 21 days after verdict and judgment. All right, essay 5. How many of y'all were really shocked at getting a remedies essay? No, you did not need to talk about product liability in that essay. Tell me in the chat if you were surprised by remedies. Yeah, don't be surprised if you get it again, because it is the second most frequently tested subject behind PR. So they love testing remedies. Yeah, I predicted it. So let's look at the fact pattern. All right. So what damages can Perry recover and what equitable remedy or remedies can Perry obtain? So this tells us, look, this is really a pure remedies question, maybe a tiny bit of contracts, but this looks more like a pure remedies question. So years ago, Perry purchased 2 baseballs that he understood were autographed by members of championship teams. One baseball was signed by the Junction City Jaguars team, the Jaguars, and another was signed by the Sluggers. Because Perry knew nothing about the value of these baseballs, this is getting at a mistake, he entered into separate contracts with his niece, Denise, a sports memorabilia expert, to sell each of them. Aware of Perry's ignorance of the value of his baseballs, Denise told Perry that the Jaguars baseball was a counterfeit worth only $20. As a result, Perry sold the Jaguars ball to Denise for $20. In fact, the Jaguars ball was worth $5,000 on the open market, so there's some fraud happening there. Denise told Perry that the Sluggers baseball had a fluctuating value and that it could sell for at least $1,000 and likely more. Denise sold the Sluggers baseball to Bob for $10,000, but told Perry that it had only sold for the $2,000 she gave him. With the remaining $8,000 that Denise received from Bob, she purchased a Voy car that triggers constructive trust, equitable lien. Ironically, since Denise purchased the Voy, interest by collectors in Voy cars has vastly increased, and her Voy is now worth $20,000. Whenever you see somebody who does something fraudulent and they get property that really belongs to somebody else, and then that goes up in value, then you want to think constructive trust, equitable lien. Denise still has the Jaguars baseball and the Voy car. After learning of Denise's deception concerning the baseballs, Perry filed suit against her for fraud. So here we're talking about fraud, not breach of contract. The court has ruled in Perry's favor. So they've found it, right? So you're just dealing with the remedies. So first, we look at monetary remedies, their damages. So damages P can recover, compensatory damage for the Jaguars ball, he can get the extra money, the $49.80 that he's owed. I'm going to put the fact pattern up at the same time. I think it can be helpful. Sorry, I should have done this the whole time. So for that Jaguars ball, it was worth $5,000. She gave him $20. He can get the $5,000. So we can get the other $49.80. For the Sluggers ball, he can get that extra $8,000 from her for his compensatory damages. Equitable remedies, constructive trust, Jaguar ball, and you're going to want to talk about an equitable lien, but you wouldn't really do it here. But you always want to talk about both of those for the Jaguar ball. All right, is that it? Yeah, that's it. So this one's pretty straightforward, really just getting at the compensatory damages, your equitable remedies here. So not too crazy on remedies, but you have to use all the facts. You really have to use all the facts in the fact pattern. All right, now let's talk about this PT. So State v. Dolan, or Dalton rather. I may or may not do another PT workshop going through this. I am going to do, just as a heads up, I am going to do a workshop. I haven't decided on it yet. You can't sign up for it yet. But I will talk about taking a PT without hard copies. Yeah, Alan, it should have had the Voy car. I don't know. You know what? Let me update this. I think something got deleted. I think the equitable lien might have been for the Voy car. I'm going to go back and double check that. Thank you. Because I did this and I was cleaning it up. I might have cleaned it too much. Thank you for that. So I'm going to do a webinar at some point with tips on taking the PT without hard copies. It'll be free, but with all of my webinars that I do, you have to register for them. You can't just find them on YouTube. Like then we have a YouTube subscription. They will be there, but you can join live and watch it for free. So make sure you try to really come live, because you also have the option to ask questions, etc. So here, your job was to persuade the judge. You had to write a closing argument. Closing arguments tend to throw people off. They're pretty common. So know how to do it. So you had to draft a closing argument, and they want to argue that the state has proved the elements of second-degree murder, or in the alternative, at least involuntary manslaughter. This PT, just like the essays, there was just a lot of ambiguity. There really, really was. And you really had to be able to grapple with that. And not just state facts, but really analyze the facts. So let's look at this. I'm just going to go through the PowerPoint. I'm not going to go through the whole PT. I think what I'm going to do is do a workshop, a webinar, using this PT as an example and talking about how to do it, with in the new format remotely. So it's persuasive, closing argument, organized by argument, right? So your headings should have been: the state has proven defendant Dalton committed second-degree murder. Second heading: the state has proven at a minimum defendant Dalton is guilty of involuntary manslaughter. So these should be two of your major headings. In each of those, for the second-degree murder, your rules should have come from the statute, and the McNally case. Should have explained McNally, so done a rule proof of that, and analogized to McNally. And these are some of the facts. It was a loaded gun. He knew it was loaded. Pointed the gun at the victim, knowing it was loaded. Tried to clean it, hide evidence. He did express some regret, right? He did express some regret. So there's some counter argument. That's a fact that goes against us. And this is a big thing with counter arguments. And I did, for my revised MPT course, I actually talked about this pretty explicitly. You know, when you have the facts of our case and they're not as extreme as a case in the library, then you want to really focus in on that. So this case wasn't as extreme as McNally with the behavior after the incident. So you have to deal with that. In McNally, if there was second-degree murder, because we're analogizing to it, so there was a conviction there, how do I deal with the fact that mine's not as extreme? You have to grapple with those facts. So I think not doing that resulted in a lower score. And then the second one, at a minimum, guilty of involuntary manslaughter, again, the statute, and then Freud, rule proof of Freud, and analogize to Freud. All right. I'm going to look at some of these. I'm going to look at some of the questions that people had. For those of you, there are I have free workshops that where you can check out some of my classes. You go to bar-md.com. I'm going to put a link. There's a free study resources tab right there. I put the link at the bottom. There's a free study, and there you can sign up for some of the free lectures, and we do have some of you can see my style of teaching. I go slower. I focus a lot more on how. Yeah, for CalCIPRO, no, timeliness wasn't the only California aspect. It was also the actual motions filed. And you should get a confirmation when you sign up for a score review, yes. And you absolutely need to do counter arguments in every single PT. And yes, Kelly, this has been recorded. You'll be able to watch it. That somebody said, why am I teaching PT without a hard copy? Because you will not have hard copies. The California bar will be administered remotely or on a computer only. You will not have hard copies. So make sure that you are familiar with how to do that. And I have strategies for that. Gee, I don't think I understand your question. And then Faith asked, hoping to pick up our prep course to prepare for the Cal Bar. Yeah, workshops. These are all the stuff I do is everything we're doing except for some of the checkups. They're all on demand. I've just been re-recording basically everything, making it more user-friendly, going in more detail. The live classes that we do, the live component is through these essay checkups. So you can do the class, just the lectures, or you can add on the live component. Yeah, and I would check out Core Plus. It includes all the live components. The PT score is calculated like everything else. So people's hands are raised. Does that mean you want to ask a question? I don't know if there's a limit for the size of the monitor. I don't know. That we haven't figured out. Okay, let me let people ask questions. All right, that's it, everybody.
Hello?
Oh, Mark. Okay, yep.
Yeah, can you hear me now?
Yep.
Yes. Do you know if Kaplan is gonna just take over the MBE portion of the exam and not the essays and performance stuff?
The essay and PT, that stuff is going to happen starting in July.
Okay, thank you.
Which is fine. That's totally fine. All right, everybody, hang out for a minute. I'm going to stop recording and I'm going to give you the little promo that we're doing for everybody that's here live. When you sign up for a score review, you should get a confirmation. Let's see, I just got a ton more questions in, but I'll answer those after. So let me stop recording.